Hi everybody, Phil Snyder, GunClassUtah.com. Hey, today I'm going to do a video on the 2025 Utah Concealed Firearm Permit Refresher course. This will be on Utah's weapons laws. So let's get started here. Definitions. It's important to know what an antique firearm means. Any firearm, including any firearm with matchlock, flintlock, percussion cap, or similar type of ignition system manufactured in or before 1898. A firearm that is a replica of any firearm described in subsection 1A if the replica is not designed or redesigned for using rimfire or conventional centerfire fixed ammunition, or uses rimfire or centerfire fixed ammunition that is no longer manufactured in the United States or is not readily available in ordinary channels of commercial trade. Or that is a muzzle loading rifle, shotgun, or pistol and is designed to use black powder or a black powder substitute and cannot use fixed ammunition. Antique firearm does not include a weapon that incorporates a firearm frame or receiver, a firearm that is converted into a muzzle loading weapon, or a muzzle loading weapon that can readily converted to fire fixed ammunition by replacing either the barrel, the bolt, the breech block, or any combination of these. The definition of a firearm means a pistol, revolver, shotgun, short-barreled shotgun, rifle, or short-barreled rifle, or a device that can be used as a dangerous weapon from which a projectile is expelled by an explosive action. Handgun means a pistol, revolver, or other firearm or any description from which a shot, bullet, or other missile can be discharged, the length of which, not including any revolving, detachable, or magazine breech, does not exceed 12 inches. Minor means an individual under 18 years of age. Short-barreled rifle means a rifle having a barrel or barrels of fewer than 16 inches in length. Short-barreled rifle includes a dangerous weapon made from a rifle by alteration, modification, or otherwise if the weapon as modified has an overall length of fewer than 26 inches. Short-barreled shotgun means a shotgun having a barrel or barrels of fewer than 18 inches in length. Short-barreled shotgun includes a dangerous weapon made from a shotgun by alteration, modification, or otherwise if the weapon as modified has an overall length of fewer than 26 inches. Shotgun means a smoothbore firearm designed to fire cartridges containing pellets or a single slug. Slug means a single projectile discharged from a shotgun shell. Violent felony means the same as the term is defined in 76-3-203.5. Now that we have those definitions out of the way, let's go over when a firearm is considered to be loaded. Now, this really did not matter. It hasn't really mattered much after 2021 when constitutional carry was passed. But prior to 2021, before constitutional carry was passed, this was more relevant because back then, you would have needed a firearm permit to carry a concealed loaded firearm on the street. So a firearm is considered to be loaded when there is an unexpended cartridge, shell, or projectile in the firing position, which means if it's in the chamber in a semi-automatic, or if it's a revolver, it's in line with the barrel. Handguns are also considered to be loaded when an unexpended cartridge, shell, or projectile is in a position whereby the manual operation of any mechanism once would cause the unexpended cartridge, shell, or projectile to be fired. And a muzzle loading firearm is considered loaded when the muzzle loading firearm is capped or primed and has a powder charge and ball or shot in the barrel or cylinders. The provision in this chapter does not specify that the firearm in the prohibited or allowed conduct, unloaded or unloaded. The prohibited or allowed conduct includes if the firearm is either loaded or unloaded. So let me just show you what this looks like on a semi-automatic handgun, okay? So I've got a cleared Glock here. I'm going to lock the slide back. The gun is clear. I verified that. It's probably hard to see on the camera. So what this means is if you've got a semi-automatic handgun that's magazine fed like the Glock, in order for it to be unloaded for carry, the chamber would need to be empty here, which it is. You can have the loaded magazine in the gun. These are dummy caps. They're dummy rounds. They're not real rounds. But you would be able to carry the gun with the magazine in it, and that is considered to be unloaded. Okay? And the reason is it's compliant this way is because the chamber is empty. Remember, the firing position has to be empty. And it's also in a condition to where it requires 2 mechanical actions to make it fire. Remember, it said 1 mechanical action would be a loaded gun? Well, this requires 2 when it's set up this way because you have to rack the slide, which just chambered around into the chamber, and then pulling the trigger is 2 mechanical actions. So, as I said, because we have constitutional carry now, and you don't need a gun license to carry a concealed loaded firearm, and you've always been able to carry a concealed loaded firearm with a permit, it is irrelevant. Where the relevance still comes in to play is for those 18 to 20-year-olds that do not have a firearm permit. They are forbidden by law to carry a concealed loaded firearm. And so if you're an 18 to 20-year-old listening to this video, the manner that I just showed you on that Glock, having that magazine in the gun is okay, and that chamber is empty, that would be how you would have to carry until you get a firearm permit. Once the 18 to 20-year-olds get that firearm permit, then it can be loaded. Also, one thing to keep in mind, if you're 18 to 20-year-old, not only does your gun need to be unloaded when it's out in public on the street, it has to be open carry where it's clearly visible, or it can be a Class A misdemeanor. Okay? So let's look at the revolver, what that looks like. I've got a revolver. It's been cleared. There's nothing in here. In order for a revolver to be unloaded, I'm thinking, you 18 to 20-year-olds, if you're over 21 or you've got a permit on a constitutional carry or you've got the permit, it doesn't really matter. But again, if you're an 18 to 20-year-old and you're carrying a revolver, basically, it would make this 5-shot revolver a 3-shot revolver. You would need 2 empties in the cylinder. Okay? So, I've got 3 cartridges in here in this 5-round cylinder. And what you need to do is you would need to set this up to where the firing position is clear, which it is. And then you need one immediately next to it empty as well, depending on the direction of the cylinder. Now, this cylinder goes counterclockwise when it's cocked or the trigger is pulled. So if I have one in the firing position that's empty, and then I have the one immediately next to it, I've got 1 mechanical action. Pull the trigger. It doesn't fire because that one was empty right next to it. Pull the trigger again and it would fire. That would be 2 and that would be okay. So just remember that. If you're the 18 to 20-year-old, you could have the fully loaded magazine in the gun in a semi-automatic as long as your chamber is empty. And if you've got a revolver, you need to have 2 out of those cylinders empty, and it just needs to be set up to where the empty is in the firing position and the one that is immediately next to it that's going to rotate and fire if it wasn't empty. Here's some other definitions that are going to come in handy later. Enter means intrusion of the entire body. Fully automatic weapon means a firearm that fires, is designed to fire, or can be readily restored to fire automatically more than 1 shot without manually reloading by a single function of the trigger. A house of worship means a church, temple, synagogue, mosque, or other building set apart primarily for the purpose of worship in which religious services are held, and the main body of which is kept for that use and not put to any other use inconsistent with the building's primary purchase. Machine gun firearm attachment means any part or combination of parts added to a semi-automatic firearm that allows the firearm to fire as a fully automatic weapon. Also need to know, readily accessible for immediate use means that a firearm or other dangerous weapon is carried on the individual's person or within such close proximity and in such a manner that it can be retrieved and used as readily as if carried on the individual's person. Readily accessible for immediate use does not include a securely encased firearm. Securely encased firearm means a firearm that is not really readily accessible for immediate use. Securely encased firearm includes a loaded or unloaded firearm located in a gun rack in a closed, locked, or unlocked case or container, or in a trunk or other storage area of a motor vehicle. Securely encased firearm does not include a firearm that's placed in a glove box or console box unless the firearm is also in a holster or other case which covers the trigger mechanism. So these definitions are definitely going to be important later on throughout the weapons laws. Okay, this law applies to 18 to 20-year-olds in the state of Utah. If a person under the age of 21 and over the age of 18, it is illegal for them to carry a concealed firearm, whether it's loaded or not. However, the Utah Constitution states that firearms laws such as this and all the other ones, there are no restrictions for anybody over 18 to carry a firearm or have one loaded in their residence, their real property, their vehicles that are lawfully in their possession, or vehicles that are in the lawful possession of somebody else that has given them permission to carry the gun, or in the person's business under the actor's control. In this one, concealing an unlawfully possessed short-barreled shotgun or short-barreled rifle is a second-degree felony. Unlawfully carrying a firearm in a vehicle. If the actor is 18 years of age or older and carries a firearm in a vehicle that is readily accessible for the actor to immediately use, and is in the vehicle which the actor is not lawfully present, or is carrying a loaded rifle or shotgun or muzzle-loading rifle in any vehicle, is a Class B misdemeanor crime. However, if you have a concealed firearm permit, standard or a provisional, including the 18 to 20-year-olds, it's okay if you've got the license to carry or some other temporary permit. It is unlawful to carry a dangerous weapon at an elementary school or a secondary school. So this includes firearms and any other dangerous weapon. However, if you have a concealed firearm permit, the standard permit, you're over 21 years of age, you can. The 18 to 20-year-olds with the provisional firearm permit cannot. They have to wait until they get their standard firearm permit. Also, this law obviously does not apply to law enforcement officers or school guardians or armed security guards under the new School Safety Act that was passed recently. Carrying a dangerous weapon at an institution of higher education, also known as public colleges and private colleges and universities. It is unlawful unless you are a law enforcement officer or you have a provisional or a standard Utah concealed firearm permit or a temporary Utah concealed firearm permit. So as long as you've got either a provisional or a standard concealed firearm permit, including you 18 to 20-year-olds, you can carry in those public colleges and universities and private ones. It is unlawful to carry a dangerous weapon at a daycare unless you have either a standard or a provisional Utah concealed firearm permit, or you are a law enforcement officer, or that daycare is part of your residence or real property. They made a change this year. It used to be that the provisional 18 to 20-year-olds could not carry even with a permit at a daycare center, and now, effective May 7th of this year, 2025, they can. Threatening with or using a dangerous weapon in a fight or a quarrel. A lot of folks get arrested in road rages for doing this very thing. They threaten somebody with a gun when they're angry, and they're not in fear of their life. They're not doing it for self-defense reasons. They're just angry, and they're just trying to intimidate somebody. Pretty serious crime. It's a Class A misdemeanor. So basically, the elements are: if the actor threatens or uses a dangerous weapon in a fight or a quarrel in the presence of two or more individuals, they either draw or exhibit some other dangerous weapon in an angry and threatening manner, or they unlawfully use a dangerous weapon in a fight or a quarrel. This section does not apply if you threaten to use that dangerous weapon or you draw that gun on somebody, if you are doing so under lawful self-defense, under Utah self-defense and defense of a person. So in other words, if you drew a gun on somebody and you weren't angry and threatening, and you were doing it for a lawful purpose, such as, maybe some aggressive person was threatening you and they were walking towards you aggressively, and you felt like you were going to be attacked and you drew your firearm on them, I would say that, that sounds like could be a reasonable response. You just have to be able to articulate that, or it's going to be a crime. Possession of a dangerous weapon with criminal intent. If you possess a dangerous weapon with intent to use it in a crime, it's a Class A misdemeanor. Typically, this would be like if, let's say, somebody was going to do a robbery and they were caught and they admitted to the cop that they were going to use a firearm that was found on them during a search, then this would be an added charge they could add on their booking sheet. Improper discharging of a dangerous weapon from a vehicle or across a highway, things like that. That is unlawful. However, if you are acting under lawful self-defense, under paragraph 5 here, that would be a defense to that charge. Felony discharge of a firearm. This occurs when the actor discharges a firearm in the direction of any individual or in the direction of any vehicle or structure like a house, and they do that with intent to intimidate or harass another individual. Think drive-by shootings here. This is a felony. Possession of a dangerous weapon by a minor. It is unlawful for a minor to possess a dangerous weapon. If the minor is younger than 14 years of age, this section does not apply if they're possessing the dangerous weapon and they have the permission from the parent or guardian, and they're accompanied by that parent or guardian or other responsible adult, and they do not use that dangerous weapon in the commission of a crime, then it's not a crime. If the minor is 14 years of age and under the age of 18, they can possess a dangerous weapon other than a firearm if they have permission from the parent or guardian, and they do not use that in a crime. So you have to be over 18 years of age to possess a firearm, so that if they are over 14 and under 18, a parent could give them permission and not be with them to possess some other dangerous weapon like a knife or something like that, or some pepper spray with that parent's permission. Also does not apply if the minor is at a shooting range or a hunter safety course and they got permission from their parent to do so. Parent or guardian providing a firearm to a violent minor. If you're a parent or guardian and you provide a firearm to a violent minor, and the definition of a violent minor would be one that has been convicted of a violent felony or adjudicated in juvenile court for an offense which would constitute a felony if they were an adult, that would be a crime, a Class A misdemeanor on the first offense. If you're a parent or guardian and you have knowledge that your minor child or somebody that's in your care is in possession of a dangerous weapon, that is a crime. If you don't take reasonable steps to remove that dangerous weapon from that minor. It is unlawful to sell a firearm to a minor. You're guilty of that if you sell a firearm to a minor, and at the time the actor sells the weapon, the minor is not accompanied by a parent or guardian, third-degree felony. Carrying a dangerous weapon while under the influence of alcohol or drugs. If you are carrying a firearm readily available on your person and you are under the influence of alcohol, it's the same standard as a DUI, that's 0.05 BAC or higher, or you are under the influence of either prescription drugs or medical cannabis also applies. Correction, if you are under the influence of alcohol or prescription drugs, that would be a crime. It could also be a crime if you're under the influence of a controlled substance. However, there are exceptions. If you have a medical cannabis card or you're under a doctor's prescription for some other drug, as long as that is being used as it's prescribed and it does not endanger you to carry that firearm or somebody else, then there would be a defense to that. There's also a defense to that charge if you're using the firearm under lawful self-defense or the firearm is securely encased at the time when you were found to be intoxicated or under the influence of drugs. It is unlawful to possess a dangerous weapon in the secure area of the airport. Secured areas at the airport are defined as a posted sign in front of the secured area, such as the Salt Lake Airport. When you go up the escalator, there's TSA, the metal detectors, and there is a sign, no weapons. Anything beyond that is considered to be a secured area. If you're a law enforcement officer or if you are in the military, whether that is the U.S. military or the state military, such as the National Guard, and in the performance of your duties, that would not be a crime. So there's a couple of things here. It makes it more serious if you intentionally or knowingly possess a dangerous weapon in that secured area versus recklessly or with some other criminal negligence. The penalties vary quite a bit. Paragraph 6 says, if you carried the dangerous weapon into the secured area in a reckless or negligent manner, you may receive a written warning for a first offense and may not receive a citation or any other form of punishment. However, on a second or subsequent offense, you may receive a written warning or a citation. If the officer issued a verbal warning or a citation and the law enforcement officer has determined that you may lawfully possess the dangerous weapon, they may allow you at your option to temporarily surrender custody of the dangerous weapon to the law enforcement agency to be retrieved at a later date, or you may exit the secure area with the dangerous weapon. If the law enforcement officer is unable to confirm the actor can lawfully possess the dangerous weapon, they will book it into evidence and allow it to be retrieved at a later date if it is determined that you could legally possess it at the time you were in contact with the law enforcement officer. Law enforcement, if they do this, they shall provide written instructions how you can retrieve the dangerous weapon upon your return. Law enforcement officers have 3 days to determine the legal possession of the firearm they seized into evidence. Prosecutors are not allowed to state in the court sentencings a forfeiture of your firearm that was seized if it was lawfully possessed at the time. Trespass with a firearm in a house of worship or a private residence. Trespass with a firearm occurs if you take a firearm into a house of worship when notice has been given, and they don't need signs. They can post them. They can personally communicate that to you, or they can have a policy with their church, or they can have notification on BCI's website of their intent to keep firearms out of their church. But if you knowingly, intentionally do that in possession of a firearm, that would be an infraction. That would be something that you wouldn't be arrested for, but it would be a citation that you'd have to appear in court for and pay a fine. The other category is private businesses. In the state of Utah, there's no law on the books that says it's unlawful to carry a gun into a business. However, businesses have the right to make them gun-free if they would like to. Usually when businesses contact somebody in this situation, it's because they're either trying to open carry into the business or they are carrying a concealed gun that's not hidden very well. The business owner that works in the store or establishment sees the firearm and they ask them to leave, and they state they have a no guns policy. They can post signs. They can give the same notice as the churches and houses of worship. However, there's no law behind it. But if you are stopped by a business owner and they do not allow guns in there, just comply, apologize to them, tell them you didn't know, and then take their instruction. They're probably going to tell you to go secure it in your car, or if you don't want to come back there, that is your choice. If you refuse to leave when somebody has trespassed you at a business with a firearm, if they call law enforcement, it's very likely that you'll receive a criminal trespass, because they do have the right to refuse service to anybody, in this case, weapons being brought in there. So just comply and be nice and don't do that. For you 18 to 20-year-olds, it is unlawful to carry a loaded firearm in a public area if you're between 18 and 20, unless you have a provisional firearm permit. Legal update for everybody. Thanks for watching.